So welcome to the afternoon session. We will still have three quite challenging, substantial, and I'm sure interesting rounds of discussions before closing this conference. I hope you still have the concentration, the energy, the interest in following our discussion this afternoon. It's a long way, but we have very serious stuff to talk about. And I want to thank all the speakers from the morning session. This was really extraordinarily substantial and interesting. Thank you very much for your contributions. So we now will move to our panel on the report of the Raoul Wallenberg Center and the New Line Institute. We already mentioned it several times at the beginning. Very profound, comprehensive, international research, how far Russia's war in Ukraine fulfills or meets the criteria of the UN Convention to Prevent Genocide. And I'm very happy to welcome Professor Irwin Cotler. At least digitally, he will talk to us from Canada. He's the international chair of the Raoul Wallenberg Center for Human Rights, an emeritus professor of law at the McGill University, and last not least, of course, former Minister of Justice with a very remarkable performance in Canada and Attorney General and longtime member of the Canadian Parliament, and all of us who are engaged in democracy promotion and protection of human rights globally know him as a real advocate, as a hero of human rights. Welcome, Irwin. I will briefly introduce also our other speakers. Unfortunately, this is a male-only panel. We asked several female experts, but we're not lucky. So I hope you will excuse us. Next to me, Oleksandr Merezhko, also a long-term friend and partner from Ukraine. Thanks for coming the long way from Kiev, Oleksandr. He is a professor in international law and at the same time member of the Verkhovna and chairman of the Committee of Foreign Affairs and Interparliamentary Connections of the Ukrainian Parliament. So he has a kind of double qualification to speak to us today. Welcome. Next one, Professor Christian Tomuschat. Maybe we can name him the doyen of the international law community, academic community in Germany. He was teaching at the Humboldt University in Berlin, International and Constitutional Law, and a member of the UN Human Rights Committee from 1977 to 1986, and then member of the UN International Law Commission from 1985 to 1996. So welcome very much, Mr. Tomuschat. Good to see you. The next one, Professor Dainius Žalimas. He is Professor of Constitutional International Law and Dean of the Faculty of Law at the Vytautas Magnus University in Kaunas. Head of the Law and Democracy Center, the Justice Hub for Belarus, and member of the European Commission Democracy Through Law, also known as the Venice Commission. So thanks for joining us. And last but not least, Yonah Diamond. He's also representing the Raoul Wallenberg Center for Human Rights. He's an international human rights lawyer and principal author of the expert report I've already mentioned, an independent legal analysis of the Russian Federation's breaches of the Genocide Convention in Ukraine and the duty to prevent. And this is what we are talking now. So I would first like to then invite Irwin Cotler to give an introduction in the main findings of the report and give an interpretation also regarding the political conclusions from this study. And then we will go into hopefully vivid conversation here on the panel. Irwin, are you ready?
Yes. Yes. May I begin by... May I begin, Rabbi, commending you for your leadership in the organizing of this timely and significant and compelling international conference respecting Russia's international crimes against Ukraine. I regret only that I'm unable to be with you in person and to benefit not only from the presentations in their depth and breadth, but from the personal encounters that make such a gathering so resonant. The theme of the report, which I'll be sharing with you, is the report jointly published by the Raoul Wallenberg Center for Human Rights and the New Lines Institute, respecting the Russia's breaches of the Genocide Convention in Ukraine and the corresponding responsibility, obligation to prevent and protect against a genocide. This report, the first of its kind, which was published toward the end of May 2022, has benefited from consultations with and contributions from distinguished scholars of genocide and international law, from intelligence assessments, linguists who assisted us in the examination of the evidence. And as you've mentioned, Ravi, the principal author is Yonah Diamond, legal advisor at the Wallenberg Center and a member of this panel. The report has also benefited from extensive work that, for example, the Wallenberg Center has done on the issue of genocide. This is not the first report of its kind that we published, also with the New Lines Institute. We did a very comprehensive report with respect to the mass atrocities constituting acts of genocide targeting the Uyghurs, the Xinjiang region of China. I might add that as a result of that report and its analysis by Foreign Affairs Subcommittee on Human Rights of the Canadian Parliament, this led the Canadian Parliament to become the first parliament to make a determination that these acts targeting the Uyghurs constitute acts of genocide, which has subsequently been followed by other parliaments. Indeed, the determinations here with respect to genocide made by a Canadian-based NGO, by a Canadian parliament, are also anchored in important principles and precedents of the Supreme Court of Canada in this regard. I will reference just two. The first was a trilogy of cases decided by the Supreme Court of Canada in 1990, known generically here as the Kijkstra cases et al., in which the court made a determination affirming the constitutionality of Canada's anti-hate legislation and incitement, prohibition of incitement to genocide, and made the following remarks in support of its conclusion. The court said that, and I quote, "The Holocaust did not begin in the gas chambers. It began with words. This, as the court put it, are the catastrophic effects of racism. This, as the court put it, are the chilling facts of history." In a second judgment, in what has come to be known as the Mugesera case, actually one in which I participated in as an intervenant, then the Minister of Justice and Attorney General of Canada, the court held that the very incitement to genocide constitutes a violation of the Genocide Convention, whether or not acts of genocide follow. Mr. Mugesera had come to Canada in 1992. He sought refugee status. The genocide targeting the Tutsis in Rwanda occurred, as you know, in 1994. In the course of those refugee proceedings and other appellate review proceedings, I won't go into it. The case came before the Supreme Court of Canada where he was being prosecuted with regard to the crime of incitement to genocide. And Mr. Mugesera said, well, how could I have been prosecuted for this crime? I came to Canada in 1992. The genocide in Rwanda occurred in 1994. I wasn't even there. And the court made the determination that his direct and public incitement to genocide in his involvement in Radio Kalina and the like constituted a breach and violation of the Genocide Convention itself. It is a stand-alone crime and thereby was held accountable. Accordingly, may I summarize briefly against this backdrop the three principal conclusions of this report. First, that Russia is responsible for direct and public incitement to genocide, which, as I mentioned, is a standalone crime and breach of the convention. Second, that Russia is responsible for patterns of mass atrocity crimes, including war crimes and crimes against humanity, from which can be inferred an intent to destroy Ukrainians as a protected national group under the Genocide Convention. And third, that the ongoing mass atrocity crimes resulting from the unprovoked crime of aggression, underpinned by the direct and public incitement to genocide, establish a serious risk of genocide, thereby mandating and obliging all state parties to the Genocide Convention to prevent and protect. I would add, though the report does not expressly make this finding or recommendation, that the ongoing, unprovoked crime of aggression in the Ukraine mandates, in my view, and others have mentioned this, the need to establish an independent special tribunal for the crime of aggression. This remedy is not now available under the other remedies that we have been speaking of, whether we refer to the ICC or ICJ and the like. This is a recommendation, in fact, that I've been involved in along with Hans Karel and David Crane. We've produced a white paper for this purpose, as have others. And actually, later today, I'm participating in a forum, particularly to seek to advance this recommendation. May I elaborate briefly on each of these principal findings. The first, where I mentioned that Russia is engaged and in the crime of the incitement to genocide, prohibited, as I mentioned, as a standalone crime under the Genocide Convention. This is, the report underpins this with broad-based evidence, and I'll just, in a series of one-liners, summarize those evidence. The first are the repeated denials by Russian authorities at the highest levels of the very existence of a Ukrainian people, of the very existence of a Ukrainian identity. The ongoing dehumanization and demonization by state officials, orchestrated state incitement, summed up really in the ongoing use of the need to denazify the Ukraine, used as a justification for the invasion to begin with, and as an ongoing justification respecting the mass atrocities that are continuing. A third is what has come to be known as the false accusation in the mirror, a powerful, historically recurring form of incitement when the perpetrator, in this instance, Russia, accuses the protected group, in this instance, the Ukrainians, of themselves perpetrating the very genocidal acts that the perpetrator himself is engaged in. There is also the ongoing characterization of Ukraine and Ukrainians as an existential threat to Russia, not unlike, and references made to this in report documents this again and again, of Nazi Germany's existential threat at the time, and where Putin on May 8th, 2022, fully reported in the report, I reference this in particular, I remember it, it happens to be my birthday, May 8th, one day before, of course, of Russia's celebration of its victory day over the Nazis. Putin sent a telegram to Russian-backed separatists claiming that Russians, quote, are fighting for the liberation of their native land from the Nazi filth, a kind of ongoing metaphor and message of incitement, and vowing that victory will be ours like it was in 1945, with the Russians thereby further reinforcing its crime of aggression through the demonizing and dehumanizing Nazi metaphors. Second point, and move more quickly. Second finding, what distinguishes genocide from other mass atrocity crimes is the intent to destroy in whole or in part a protected group, as such as Ukrainians are under the Genocide Convention. This intent can be inferred from the evidence of a general state plan, that is to say, statements by officials, documents, policies, all of which are documented in the report, or from a systematic pattern of mass atrocity crimes targeting the protected group, which the report documents, and which include, and again in a series of findings, mass killings, as in the well-documented Bucha massacre and the graphic murders there, deliberate attacks on shelters, on humanitarian corridors, on evacuation routes and the like, indiscriminate bombing of residential areas using cluster munitions and prohibited weapons as we speak and taking place as we speak, deliberate and systematic imposition of life-threatening conditions, destruction of vital infrastructure, again happening as we meet, whether we speak of the mass targeting of water, power, communication facilities, medical facilities, the ongoing attacks on civilians and civilian infrastructure including also on food and energy supplies and the like. In other words, targeting the basic necessities of life that underpin civilian life and infrastructure, and intended to bring about the physical destruction of the targets. Rape and sexual violence accompanied by the direct and public incitement to genocide, forcible transfer of Ukrainians, including hundreds of thousands of the children, itself an act-specific mass atrocity constitutive of genocide and the like, which brings me to the third and last finding, that this criminal aggression, this direct and public incitement to genocide, this pattern of mass atrocities that I've described, the whole evidence of an intent to destroy the Ukrainians as a protected group have created a serious risk of genocide, and thereby the duty of state parties to the Genocide Convention to protect and prevent this genocide when a serious threshold has been reached, and as the report documents, such a serious risk of genocide and threshold has been reached, and therefore mandates state obligation to prevent and protect, to undertake the necessary actions to protect the vulnerable and targeted Ukrainian protected community, itself a standalone legal obligation, an obligation that under the Genocide Convention is triggered before the genocide occurs. And when the threshold of the risk of that genocide has occurred, the mandate and obligation to prevent is thereby triggered against the backdrop of all that I've mentioned, including, as I said, the unprovoked criminal act of aggression, the direct and public incitement to genocide, the mass atrocities, war crimes, and crimes against humanity themselves constitutive of acts of genocide graphically documented in the report, the whole thereby creating a serious risk of genocide and mandating the responsibility to prevent and protect. In a word, this report then and your discussions now and all that has happened since the end of May when we published our report have only served to further underscore the risk of genocide and to further underscore a call of action on all state parties to undertake their responsibilities to prevent this genocide. Thank you.
Thanks a lot, Irwin. This was a really impressive speech. I just would like to take away two of your statements. First, and Marie-Louise in her opening remarks already touched it, genocide doesn't start with the gas chambers. It starts with genocidal language, with incitement to genocide, with the demonization and dehumanization of the other. So, and the second conclusion, the obligation to act, the responsibility to protect starts with the serious threat of genocide. Yeah, to prevent it, we must not wait until it's fulfilled. So it's just the other way around. And this is a strong message to the European governments to meet this responsibility. So I would like to enter now our panel with a short round of comments. Please just pick up what you think is most important in the report and then for our debate in your view. I will just go along here the Raoul.
Thank you. First of all, I would like to personally express my deepest gratitude to Professor Cotler and to all our colleagues who had prepared this excellent report. And it came out in a very timely fashion. And this is a good example of deep theory. And at the same time, it has a tremendous practical importance, especially for our committee, because beginning with the 24th of February, me and my colleagues of my Committee of Foreign Affairs, when we are communicating with our counterparts, members of parliaments of other countries, we're trying to persuade them to recognize as a genocide Russia's crimes against Ukraine. And I'm using this as a document. I'm using the arguments put forward in this report. That's why I'm deeply grateful for this report. And again, I want to stress that it has practical importance. At the same time, some of our counterparts, when we're asking them to recognize genocide of Ukrainian nation, some of them use as an argument something like, we should wait, it's a political issue. On a political level, we can recognize this as a genocide, but before our parliament will recognize it officially, we should wait until there will be official decision of any international court. And my colleagues from this organization, they gave to me excellent counter-argument, because this is also, we should remember that this is also about prevention of genocide, which is unfolding before our eyes. So it's moral duty to recognize genocide and to struggle against genocide. And the last point I would like to make, you see, sometimes some politicians in the West, they are reluctant to use the term genocide. And the reason for that is that when we openly recognize what's going on as a genocide, it creates moral obligation to do something about it. It creates obligation to fight, to struggle against genocide. Because we should remember this very clearly, that genocide is a crime against the whole humankind. It's a crime against each country, and it's a crime against each human being. That's why what's going on in Ukraine, other countries should not treat it as not ours war. It's war, it's crime against each person, against each politician. That's why we should be united in this struggle. Thank you.
Thanks a lot, Oleksandr. Professor Tomuschat, please.
Thank you, Chair. I'm extremely grateful for the report, which makes clear what is really happening and what has already happened in Ukraine. And there can be no debate on the veracity of the facts. The facts are clear, I think. One cannot dispute the terrible situation in Ukraine, saying that this is all only hypothetical, or it's just fabrication or manipulation. This is impossible according to what we know these days. Now let me, before going into more detail, make 2 points. The first point is that the Charter of the United Nations makes it a requirement for membership in the organization that you must be a peace-loving state. Only peace-loving states can be admitted to the United Nations. And of course, the Russian Federation currently is not a peace-loving state. Therefore, its place is, well, illegitimate in the United Nations. It is not a peace-loving state, and therefore, and really should have no place in the World Organization. And my second observation relates to what I just said. We have a basic principle, the general principles under Article 38 of the Statute of the International Court of Justice, which enumerates sources of legal rules to be applied by the International Court of Justice. The first one is treaties, here for us, most important treaty is the Charter and the Convention on the Prevention and Punishment of Genocide, and customary law, well, customary, but then general principles of law recognized by civilized nations. Yeah, you, in order for your legal order to be taken into account in a legal proceeding, you must be a civilized state. And I think that according to what we know now, Russia is not a civilized state. It has left the circle of civilized states, which is very, very sad to say this, but it's simply the truth. Russia is not any longer a civilized state. Now, what can be done? And first of all, the report itself shows us all the advantages and usefulness of documentation. Documentation is necessary. The documentation in the report, what we know the International Criminal Court itself investigates, and there is a special committee established by the Human Rights Council. And it is interesting that Russia was always against the establishment of such international independent inquiry commissions, which started with Syria. There's another such commission for Myanmar, and this is now another example. And Russia has always attacked such decisions by the Human Rights Council, saying that this is a privilege of the Security Council and the Human Rights Council cannot go that far. But I think this is wrong, and it is now established practice that the Human Rights Council, which is under the authority of the General Assembly, can establish such special investigation committees that seek to collect evidence before it's destroyed or obliterated or forgotten. It is important for any future proceedings to have a solid basis of documentation. And you always hear from critics, oh, when the General Assembly says something, does something, this is not really binding. But that's a wrong conclusion, a wrong inference, because such documentation will be taken as a basis for future trials. And of course, you cannot base a conviction solely on an investigation report by a political body, but it's a starting point from where you can prolong and extend your investigations. And without such documentation, previous documentation, you probably would have great difficulties to come at some conviction at the end. Let me say something about the concept of genocide. We all know that the great difficulty regarding genocide is the specific intent to destroy in whole or in part a group. But the question is, what is the factual basis? Do we have to look at an event which extends over many years in its entirety, or can individual incidents or individual problem situation as such constitute genocide without regarding the general framework? I was the head of the Truth Commission in Guatemala, and one of our main problems was whether in Guatemala genocide had been committed. And we came to the conclusion that in some parts of the country, in some places, at some point in time, genocide had been committed, but it had to be looked at specifically, not in a general way. You have certain situations where you get there are all the characteristics of genocide are present, and this is genocide, and afterwards maybe things may be changing, but the responsibility of the individuals involved in such an act remains and cannot be it cannot be deleted. Let me just make a last observation in this introductory statement. We should not forget the competence and the jurisdiction of national courts. Yeah? Crimes against humanity, everything, all the great crimes under international law are also under national jurisdiction. We do not have to rely solely on the International Criminal Court, which is highly problematic. And if a national jurisdiction started working, looking for suspected individuals who were involved in such crimes, then this would have an important deterrent effect, and we should not forget that. Of course, it's an act of courage if a public prosecutor in some countries says, I take up this case, a case that happened in Ukraine, and this Russian member of the armed forces, he committed, under those circumstances, crimes against humanity, and we shall try to initiate penal proceedings. This is an important task, I think, for national jurisdictions, and it's also an act of courage. National prosecutors and in particular ministers will never like to have such cases under their jurisdiction because it involves that great tensions will arise immediately, and so therefore they shy away. And in Germany, sometimes we have had a little bit of courage in that sense. Let me stop here and thank you.
Vielen Dank. Es ist wirklich beeindruckend, Ihnen zuzuhören. So, next one, please.
Thank you. Thank you very much. First of all, I would like to express my deep gratitude for the invitation to take part in this panel, and also gratitude for an excellent report on the genocide of Ukrainians, I must say. And therefore, I would like to share some views with regard to this report, and especially because, you know, it's very difficult to argue with the facts, with very legal assessment that is very well grounded. Therefore, I would like to share some my thoughts, which maybe go beyond the limits of the report. But first of all, just briefly, a few brief remarks responding to Professor Tomuschat. Yes, this report proves us that Russia is not a civilized country, is not peace-loving. Peace-loving, country, and therefore I just remember the UN practice because actually we all know that it is very difficult, impossible at all, to expel Russia from the United Nations, to change the charter of the United Nations, because it expressly requires any change to be approved by all the permanent members. But I remember two cases from the UN practice, and that's of course goes beyond the report. One of those cases I would recall as a sad precedent, but still a sad precedent. I mean, the case of Taiwan. The second one, that was South African Republic, when simply the General Assembly didn't recognize the powers of respective representatives of those states, just on the ground that the government wasn't representative enough, or because of the policy of apartheid. So therefore, I think, yes, it is really the question of majority in the General Assembly and of political will to act in the same way. Why still we recognize the powers of the Russian government to represent Russia in the United Nations? That would be really the way how de facto expel Russia from the United Nations. So that is the first remark. The second remark that is related to the issue of universal jurisdiction, by the way. From my own experience, I fully agree with the professor that usually national authorities, national law enforcement authorities, even national courts, they are very reluctant, they are sort of afraid to deal with those cases. Therefore, this report written by the most authoritative experts in their field, I consider it to be very important in order to persuade a little bit our, for example, Lithuanian authorities to act more actively in this field, because what I felt myself, I myself just recently appealed to our National Prosecutor General's office with the request to institute investigation against, that is also, by the way, the topic which usually is left aside, responsibility of judges for genocide and for aggression. I mean Russian judges, because the Russian Constitutional Court even five times already approved annexation of Ukrainian territories, different Ukrainian territories. And actually, I felt a little bit a sort of reluctancy to deal with, because the judges is understood, I fully understand, in the Western world, it is, a judge is really independent, it really administers justice, but in Russia, in Belarus, we have another type of justice. It's not justice at all. It's simply obedient tool of the respective authoritarian regimes in committing crimes. Even according to Russian legislation, the conclusion of the Russian Constitutional Court is necessary for the annexation. And that means that they are a part of the decision-making process, and we should deal with them also as criminals, like political leadership. So really, this report helps to encourage in a way that, you know, it's not only national scholars writing about genocide or about aggression, but also famous international scholars and joint efforts in preparing such reports. They are very important to persuade and to promote national investigations of those international crimes. Two more remarks. Actually, I just wanted to start from that. The term of genocidal war is very important. And you know, in my practice, I use this report from May already for a little bit different purpose, to persuade that we really need the special tribunal for the crime of aggression. Because really this report can serve for both purposes, for persecution for genocide and for persecution of aggression, because usually all of them, I mean both types of crimes, both aggression and genocide, usually they have some ideology behind. And really, when we recall about Nuremberg Tribunal, actually we don't remember the names, well, some of them, but frankly speaking, not all of them who were sentenced by the tribunal. But what we really remember usually, that the Nuremberg Tribunal condemned for all times the Nazi ideology. So I see here, and I rely on this report as a proof that certain ideology does exist in the Russian state. It's not simply a chaotic collection of ideas. It is united under one ideology. Of course, maybe not sufficiently consistent, but nobody cares in that country about consistency of ideology, because it's a sort of mixture between glorification of the Soviet past, of the Soviet Union, of the Soviet so-called victory in the great so-called Great Patriotic War, and as well some new neo-Nazi ideas, I must say, because if we remember, when, for example, Crimea was annexed, what was the main message? Reunification of all Russian-speaking territories into one Russian state. And in this regard, I remember I recalled, I think it was 1932, you can correct me, program of National Socialist Party that called for unification of all Germans into one great Germany. So it's identical ideology. So what I have in mind, this report is very useful in seeking to condemn, assess, and to declare as criminal all the ideology, which is, yes, even two names most popular, Russian Volt or Russianism, similar like fascism. And the main, of course, point of this ideology is the existence of one single Russian nation. Of course, by the same token, that was excellently demonstrated in the report, denying any Ukrainian identity. I must add Belarusian identity as well. And just a few days ago, I received one brochure from Ukraine, which is distributed to Russian soldiers. So the first message in that brochure is that Ukraine does not exist as a state. What is Ukraine is the territory of a former Ukrainian SSR, temporarily, illegally administered by the Western puppets. Ukrainians are not a nation as such. 97, I don't know why 97, but 97% of Ukrainians, they previously had been Russians. And only this so-called independence period distorted their national identity. But they still are Russians, and if they are not willing to be educated, then they have to be exterminated. And that is openly distributed to all the Russian soldiers on the battlefield. And by the way, one more also remark from that brochure, that Ukraine is used as a tool by the West for the revenge for the defeat of Germany in the Second World War. So, you can imagine that really it is the system of ideology. And just to add a few thoughts about this ideology, it goes beyond Ukrainian issue. All the territory of the former Soviet Union, they treat, for example, the Baltic states also as the former Soviet countries. It is called as historical Russia, to which Russia allegedly has, specific exclusive rights. Anytime they can declare any other post-Soviet state as also being temporarily, illegally administered by some foreigners. And also it is anti-humanistic ideology as such, because if we remember, and it was not only statements of politicians, it's also statements of, I remember very well, the president of the so-called Russian Constitutional Court. He wrote a number of articles, namely on that. Russian Orthodox Church is declaring that Russia is the only defender of traditional Christian values against liberalism from the West, which allegedly threatens traditional family, for example, and of course, all gender equality, non-discrimination of people are perceived as a danger for the Russian world. So that's, I think, one more proof that report also includes certain elements of that the ideology exists, which is contrary to the UN purposes and principles, and contrary to the foundations of our current or modern civilization. And the last remark, I'm very happy to see that the report goes in line with a little bit modified interpretation of the notion of genocide. Because what is mentioned there, that at least we can establish genocidal intent in respect of a part of Ukrainian people. And I can recall when in 2014, by the way, there are not so many constitutional courts that dealt with genocide issues, but Lithuanian Constitutional Court is one of those courts. And already in 2014, Lithuanian Constitutional Court interpreted the issue of genocide, whether the Soviet crimes under certain conditions can be described as genocide. And in a very similar manner, that is why I am very happy to see that, I mean that if the group against against which genocide is directed is so significant for the survival of a whole national group, then we can speak about genocide. And I mean, so significant. In Lithuania, it was understood, of course, wording can be a little bit different, but as civil society, as the most active people. I mean, teachers, politicians, I know, simply well-educated people, also from military. So if Soviet repressions, like Russian repressions, and it is also well demonstrated in the report, sometimes it's targeted specifically on the so-called elite, just in order to destroy the very idea of the statehood of the respective nations. So I'm really very happy to see the similarity in reasoning, both in this report and in our judgment some 8 years ago. So let me finish just simply telling that really I find this report as very important, especially for the future assessment of what we call genocidal or aggressive ideology of the Russian world. So thank you very much for your attention.
Thanks a lot, Professor Žalimas. I think it was not by accident that in your reading of the current Russian war crimes in Ukraine, the historic remembrance of the Baltic countries is resounding. So with Soviet occupation. Finally, Yonah, I have a specific question for you, whatever you else want to talk about. Why is it from your perspective and the perspective of the Raoul Wallenberg Center so important to highlight the topic of genocide? Why not just focusing on the prosecution of the already well-documented war crimes, crimes against humanity in Ukraine, or why not putting all the effort and all the political passion into the establishing of a special tribunal against war of aggression?
Yeah, thanks, Ralf. That's a good question. Part of the impetus is to apprise governments of when this genocide convention has been breached, or when we have reached a level where there's a serious risk of genocide, and that's distinct from individual criminal prosecutions. And as was mentioned earlier today, the purpose, raison d'etre, of the Genocide Convention, as in the title in Article 1, is to prevent, the parties undertake to prevent and punish the crime. And so the only way you can prevent is by responding as atrocities are ongoing, whereas individual criminal prosecutions tend to happen after the fact, especially under these rigorous international standards. And the Genocide Convention is a very unique treaty, and it's one of the foundations of international law. So I would say beyond breaching the Genocide Convention, Russia is attacking foundations of international law, the UN Charter, the Genocide Convention, as was mentioned earlier, provisional measures by the International Court of Justice, and the very historical memory of genocide by accusing its victims of perpetrating genocide as a justification and pretext. So that's the reason why genocide has a, particularly applicability to this particular context, not to mention it is a unique treaty. So we have the Rome Statute, which applies to individual criminal responsibility, but state responsibility is a distinct legal regime, though it is also overlapping with criminal standards. There are distinct standards of proof and of due diligence on governments to make their own assessments when a multilateral treaty has been breached. How do we respond? And when do we decide how much we can, how we can operationalize our duty to prevent? So, and I want to note that the independence and international nature of the report is underpinned by representatives and contributors from every UN regional group. We made sure to have at least one from each group. So this is truly an independent and international undertaking. And the duty to prevent is triggered as soon as a state becomes aware, or normally should become aware, of the existence of a serious risk of genocide. And so the purpose is also to put on notice states based on the open source and available evidence as it's unfolding. And I want to point out that it's available in 6 languages in full, also in German, and the executive summaries in 13 different languages. So it's available. But I also want to point out that we heard earlier that this might be called a debate, but I would encourage us not to think about it as a debate over whether some threshold of genocide has been reached. The Genocide Convention has 19 articles. The Genocide Convention also is more than just the definition. It includes other crimes, the direct and public incitement to genocide, complicity. There are measures to call upon the UN Security Council to suppress and prevent genocidal acts. And the definition of genocide itself is far broader than the Shoah and the Holocaust. And it took years to finalize a text. And so it's very deliberate and intentional how states agreed upon any of the 5 acts when committed with intent to destroy in whole or in part is genocide. And so I would encourage us to look at this both as a foundation of international law, as a treaty. By the way, there isn't a Crimes Against Humanity treaty at present, and a state can be held responsible for genocide, as explicitly mentioned in Article 9 of the Genocide Convention, as opposed to an individual being. So in other words, an individual can be acquitted of genocide while a state is held responsible under a lower standard. So I would encourage us to look at the Genocide Convention as we applied it as a framework. It's a framework, it's a process, and the 5 genocidal acts, of which killing is one, and was another impetus behind starting the report in light of the atrocities in Bucha. But each act, for instance, take Article 2E, the forcible transfer of children. And there's mounting evidence since we released the report of both Article 2C, the deliberate infliction of conditions of life calculated to bring about physical destruction, but also the forcible transfer of children. And the acts on a systematic, when they're committed on a systematic basis, can also contribute towards an inference of genocidal intent. These are very specific acts that the authors knew, that the drafters knew, were methods of genocide. And so when we see these acts clearly being committed on a systematic nature, and when we see how they're interconnected, that could also lead to an inference of genocidal intent.
Sie, vielleicht auch an die anderen Teilnehmer des Panels. Wer kann und soll diese Feststellung treffen? Und soweit ich es bisher verstanden habe, geht es um zwei verschiedene Feststellungen. Die eine ist, dass die russische Kriegführung in der Ukraine zentrale Kriterien der UN-Völkermordkonvention erfüllt. Wer kann und soll diese Feststellung treffen? Die zweite Feststellung ist, es besteht die akute Gefahr eines Völkermords in der Ukraine. Das ist etwas anderes. Das ist eine politische Bewertung. Es besteht die akute Gefahr, the threat of Genocide in der Ukraine. Wer kann und soll diese Feststellung treffen? Who would like to answer? Yeah. Yonah?
Sorry, I missed the first part. Who is to make the determination as to when a state is responsible?
Pardon?
I missed the first part. I didn't put the headphone.
Wer soll diese Feststellung treffen? Ja. Erste die Feststellung, dass die russische Kriegführung gegen die Genfer Völkermordkonvention verstößt. Auf der United Nations Völkermord. Und zweitens, dass wir vor der unmittelbaren Gefahr eines Völkermords stehen. Und deshalb die Responsibility to Protect greift. Herr Professor Tomuschat.
I think it depends on...
Please take your mic.
I do apologize. It depends on the circumstances. You can bring a case before the International Court of Justice in connection with an interstate dispute where the reproach is, the accusation is against the defendant state that its troops committed genocide and that therefore reparation is due. And the International Court of Justice in earlier cases said that it is independent and it does not rely and does not have to rely on a formal finding by the Security Council. That was in connection with flight. I think it was a Libya case where the court really reaffirmed its independence. It's not an institution that depends on the judgment of the Security Council. In a domestic setting, on the other hand, if an individual is placed before a domestic judge in some country, which is of course very difficult for an individual to be charged with genocide, because genocide is always a collective crime, you know? And can you really make individual persons responsible for genocide without considering the whole picture? That is a great difficulty, you know, as far as crimes against humanity and war crimes are concerned. It is much easier because war crimes can be committed by individual persons, and also crimes against humanity if those acts constitute a certain pattern. Then a conviction on grounds of committing a crime against humanity is possible. So then the question finally is the question before the International Criminal Court. The International Criminal Court, where there are many difficulties, of course, before the jurisdiction and question of immunity, and I cannot go into everything, but the question is very clear. It depends very much on the procedural circumstances. There's not just one answer to your question.
Would you like to add, Yonah?
Yeah, I would say for both, this isn't the case yet, and you often see political officials hide behind the excuse that we need to wait for a court to make that determination, when really there is a state responsibility that is triggered before any court can, especially the International Court of Justice, can make a decision. So I would say for both the breach and for a serious risk of genocide, countries need to get really serious about having internal mechanisms when they can assess when another party has injured them by breaching the Genocide Convention. And I would say not only is there a duty to prevent, and as the International Court of Justice says, that means using all means reasonably available and within your power so as to prevent genocide as far as possible, whether it's financial, military, political, or other links. And two countries, once the Genocide Convention is breached, as Professor Tomuschat mentioned, it would incur reparations if brought to a judgment at the ICJ, let's say, but also states have a right to take countermeasures when another state breaches a convention like this. And I would say, especially a peaceful countermeasure like confiscating assets that are associated with the decision makers in Russia constitutes a peaceful countermeasure. If states are giving military assistance, and I was a little disappointed earlier today, then surely confiscating Russian assets in order to repurpose those assets for the purpose of restructuring Ukraine and compensating its victims, the victims of genocide, surely seems like a perfect way to both potentially deter Russia, because it imposes a real cost on the decision makers who can make decisions from the comfort of Moscow, and also help protect Ukrainians and help them rebuild.
Thanks a lot. Professor Žalimas, you would like to
very short.
jump in?
Maybe Ukraine can use this opportunity, because already the cases before the ICJ, I mean, with regard to manipulation of the Genocide Convention, but really the request can be broadened, I think. For example, by requesting the court also to recognize that the convention as such is also breached in respect of the duty of prevention, and perhaps in respect of certain acts which can be already be qualified as genocide. I mean, Mariupol, transfer of children, maybe something else, everything what is in report.
But again, is your statement that we have to wait for a decision of the ICC?
You know, nobody prevents us from telling our own judgments, from assessing, but of course, still final legal qualification, because the only body which is competent to assess the acts as genocide in interstate relations, it is really the International Court of Justice or International Criminal Court in cases of individual criminal responsibility.
Oleg.
May I add something? Apart from courts, who can also make determination regarding genocide? First of all, a number of foreign parliaments, if I'm not mistaken, 6 or 7, including Poland, including Baltic states, they have already in their resolutions recognized Russia's crimes against Ukraine as a genocide. Second, there was a special commission by the parliament, by the Parliamentary Assembly of the Council of Europe sent to Bucha, which had prepared special report in which it recognized that there were acts of genocide committed. So we have international organization. And I would like very quickly to add to a very serious, important issue, which was raised by my colleagues regarding membership, Russian membership. The truth is, because I've been dealing with this issue since the year 2014, the truth is that when you open the text of the UN Charter, Article 26, if I'm not mistaken, there is no Russia at all, no Russian Federation, Soviet Union. And the truth is that Russia took this place on the Security Council in violation of the UN Charter. It was political, not legal decision. And I agree, there are two conditions for membership: to be peace-loving country and to implement or perform obligations under the UN Charter. We should raise this issue that genocidal state should not be member of the United Nations. And I have always been in favor of declaring it publicly, officially, as our official position of Ukraine, that we don't recognize Russia as a member state. And other countries should follow this example.
Thanks. So I would like to use the remaining 20 minutes for some questions or comments from the audience, please.
Rafi, could I jump in for a moment?
Yourself.
Thank you. I'm Klaus Bachmann from Warsaw, and I'm a political science professor. And I have a nightmare. And this nightmare is a Russian general who is so imprudent to spend his holidays in Montenegro, where he is apprehended and he is accused of war crimes and genocide. And then in The Hague, he's exonerated of genocide and he's convicted 7 years of imprisonment or something like that for war crimes. And then we have a huge campaign, of course, directed by Russia, that there never was any genocide because he has been exonerated. Why I'm saying that? Because it's the introduction to my question. Because I think we should be on the safe side with, especially with the genocide accusation, because it can turn very rogue against our own interests, I would say. And I think we should imagine that this case would be heard by judges, and we would have to convince these judges, not ourselves, not me, these judges. And these judges would probably come either entirely or in part from the countries that have abstained or have abstained or were absent in the United Nations General Assembly when the annexation or when the condemnation of the invasion were voted. So it's quite a high threshold, I would say, that is in front of such an indictment. And that brings me to the to my questions. It's mostly to Yonah Diamond, because he's the author of the report, and I read it very, very intensely. I understand your objective. It's about state responsibility, and it's about, well, actually alerting before more evil happens. But if we take that logic into individual criminal responsibility and put ourselves into the position of a prosecutor, let's say, then of course we have I think you have a strong case when you talk about incitement. You have a strong case when it comes to the forcible removal of children. That's something that I suspected already months before, and I'm very happy that I see it now in writing. But that's my problem with it. We, as the prosecutor, would still have to prove that this all happened with an intention to destroy the group, the Ukrainians, in part or in a whole. Now, the proof for that is, of course, in Russia, and it's very difficult to access. But we know from the jurisprudence of the ad hoc tribunals that there's a possibility to circumvent that by establishing certain facts which testify to the intention, where we can infer the intention of the perpetrator. In Srebrenica, this was the fact that they killed the men in adult age, which were capable to wear weapons and so on and so on. And the argument of the judges was they are significant because that's a requirement. The group or the part of the group that the perpetrator wants to destroy has to be significant for the group so that the group cannot survive without this part. And the argument was it's a very patriarchal society in Bosnia, and such a society cannot survive without a certain number of men. So it's almost a biological argument, I would say. My question to you is, if we argue with incitement, we don't have this problem. But then we also can't argue. I mean, and if we argue with forcibly removing children from the group, then we would have to prove that the children are this significant part of the group, without which the group cannot survive. And you see the problem.
Okay. Before you take the floor, Yonah, I just heard that Irwin Cotler is still with us. Unfortunately, Irwin, I cannot see you on the screen. So I would like to give you the opportunity to come back into our discussion. Please.
Yeah, thank you. I just wanted to make 2 points here, because reference has been made that there is a reluctance to make a determination of a genocide. And I experienced this when I was Minister of Justice and Attorney General. As a parliamentarian, before being appointed minister, I had chaired an all-party parliamentary group regarding genocide in Darfur. When I was appointed the Minister of Justice and Attorney General, the Prime Minister said to me, you can't call what is happening in Darfur a genocide. And I said to him, Prime Minister, does it cease becoming a genocide after we made a determination as parliamentarians, and now that I've become a Minister of Justice? And I understood that there were some concerns about the obligations that arose from it. And so I said, you know, just because the Prime Minister said, call it crimes against humanity, I said, this would not free Canada from its obligations if you call it crimes against humanity. And we went ahead and then ultimately did determine that it was a genocide. But I think what has to be understood here is that we're dealing in this genocide convention with the responsibility to prevent. And the responsibility to prevent is triggered when there is a serious risk of genocide. Not that you have to determine that the genocide has in fact occurred. And so we're talking here about a different threshold, a serious risk of genocide, and also always remembering that the public and direct incitement to genocide is a standalone crime, whether or not acts of genocide in fact follow. So here we have individual criminal responsibility, incitement, as well as state responsibility. The other point that I wanted to mention very quickly in this regard has to do with the whole denazification process, because this triggered the justification for the initial invasion and criminal aggression. It is continuing as a standing public incitement, state orchestrated incitement, for all the reasons that have been mentioned by the panel. And I think this too bears important responsibility to act in this regard. Thank you.
Wollen Sie ergänzen, Yonah?
Okay. Yeah, I can add. No, that's a good question. I mean, one thing to think about is when an eventual verdict will come out, which is in probably, you know, like 10 years or so. And so how do we respond to the situation that is very serious and ongoing? And I would say has escalated, it seems, even though Ukraine has reclaimed territory, it appears that, you know, as we enter winter with communications and power sources being targeted and, you know, the UN Special Representative on sexual violence saying that, you know, rape is used as a military strategy, and you know, and just more and more information as we uncover what's happened in occupied territories. I would say that the risk is potentially even growing, and so and that's the thing. There's a duty on states to act even before genocide conviction comes about. Yeah.
Okay. Thanks a lot. Other questions? Professor Kress.
It's not so much a question, but an observation in response to your question, Ralf Fücks, and perhaps my distinguished colleagues wish to comment. I think you have asked the key question, and I think Marie-Louise Beck and you have drawn a key distinction. The one between prevention and making statements, so to speak, after the fact about a genocide that allegedly has occurred. It is crucially important that in order or for the purpose of preventing, by definition and even logically, you don't have to say genocide has occurred. It's by pure logic. And all the obligations, moral and legal, that are triggered in order to prevent do not presuppose a completed genocide. And that's so very important also from a political perspective, because obviously it is very difficult for states to speak out and say state ABC has committed a genocide. But that's not what they have to say. It would be sufficient to say there is a serious risk, and that would trigger responsibility to protect and all the ensuing measures. I agree with my colleague, Professor Žalimas, in a decentralized international order that we still have. Every state is entitled to make that assessment individually. There is no legal obligation that prevents a state having formed its individual opinion after having consulted its international legal lawyers to make that statement. However, as a matter of political wisdom, it's of course better to act collectively. The message will be far more powerful, and there are avenues to do so. And we have perhaps not yet mentioned there are international institutions and organs that can help this process. There is, since many years now, a special advisor to the UN Secretary General, a special advisor for the prevention of genocide. So it is the core of his or her mandate to help states forming their view. Also for an international commission of inquiry, it's usual practice not immediately to state, and let's speak about this ongoing investigation we are currently having. They wouldn't say immediately there is a genocide that has been committed. They would formulate, there are indications that a genocide may have been committed. And that's all we need for prevention. When it comes to repression, so making a finding on a completed genocide, the logic and the perspective legally, morally, politically is completely different. Here, my answer to your question, Ralf Fücks, would be states should not comment on crimes committed by individuals. They should be careful, not prejudge. It's also a question of the presumption for innocence. We should not contaminate international criminal proceedings and national criminal proceedings by hasty statements. So they should confine their statements at the collective level, speak about state responsibility. That's not a crime. we don't know in international law crimes by states. So they should confine it to the level, and that's how I understand your report to work very wisely. It's on the collective level. And here it could be coupled, a statement that we believe genocide has been committed. It should be coupled by instituting the appropriate legal proceedings to have, in the end, a court to validate. And just one last sentence, it's perhaps not yet so known because the judgment has been delivered only a couple of months ago. I shall not comment on this judgment because I was on the bench when the ICJ decided this as an ad hoc judge, but in Myanmar, Gambia, Myanmar, the ICJ has affirmed jurisdiction. So the case will move to the merit stage. It's a genocide case. And the court has held for the first time clearly that the obligations enshrined in the genocide conventions are so-called, legal technical term, obligations erga omnes partes, which will enable every state party to the genocide convention to institute proceedings for genocide. And that has enlarged the possibility for states not only to claim genocide, but also to take action for a legal validation of that claim.
Thanks a lot for this enlightening statement. At least it helped my understanding of the material a lot. There was a last question in the audience, then we unfortunately have to finish the panel.
Thank you so much. My name is Katerina. I'm from Ukraine, but now I'm working with Minister of Justice in Lithuania under implementation of universal jurisdiction. And as far as Professor Žalimas what mentioned about this issue, I would like to ask you all about this issue. What do you think? Can it be effective instrument or mechanism for justice for Ukraine? What are the perspectives?
Thank you.
Professor Žalimas.
Thank you. Maybe I'll start to answer. Yes, it's a good question, but you know, just recently it was mentioned that it is erga omnes obligations, and therefore each state in principle is entitled to start even national investigations. And because in the Lithuanian criminal code we have such a provision on universal jurisdiction in respect to almost all international crimes, including genocide, by the way. Therefore, I think it is very important, but of course, we should also have in mind that it is always better, as it was mentioned as well, to act collectively, not only individually. So I wish that not only, for example, Lithuania, but much more states would start this kind of national investigations, and therefore we can speak afterwards about international arrest orders, for example, cooperation in the investigation and better defining all the circumstances. But of course, here, if to speak about national investigations, Ukraine should take lead, first of all. And as far as I know, Prosecutor General's office in Ukraine is conducting its own investigation. But of course, with certain limitations, when we have international immunities, still, I mean, even formally, they cannot institute case against president, minister of foreign affairs, the head of the government. And for that, we again need International Criminal Court or special tribunal for the aggression. That is also a sort of limitation. But I think the most important thing which we can achieve by starting national investigation, simply showing solidarity and showing to those who are responsible that we will not forget about the crimes we committed, and sooner or later they will be, you know, brought to justice.
Vielen Dank. Ich muss jetzt leider diese Diskussion hier beenden. Das ist ja nicht oft so, dass man wirklich auf Konferenzen was dazulernt und nicht nur vorgefasste Meinungen wiederholt. Für mich war das jedenfalls nicht nur in diesem Panel der Fall. Dafür möchte ich mich sehr bedanken. und würde einfach mit der provisorischen Conclusio schließen, dass in diesem Fall Staaten sich nicht hinter der Jurisdiktion verstecken können, sondern dass sie selbst eine nicht willkürliche, sondern juristisch gut beratene Entscheidung treffen müssen, ob wir es hier mit einer Gefahr, einer imminenten Gefahr eines Völkermords zu tun haben. Vielen Dank.